The Kano Progressives Congress stakeholders are raising alarm over what they call plans by supporters of the new Nigeria People's Party to unleash violence against its members through a rally scheduled to be held on Saturday. During a press conference held on Thursday at the APC Secretariat in Abuja, the group spokesperson, Rabiu Bichi, called on the police and other security agencies in Kano to protect the lives and property of its members. Bichi had this to say in response to why the group is holding a rally on the same day as NNPP supporters.
Since the embattled leader of the NNPP, Senator Rabi Musa Konkoso, came back to Kano on Sunday, where he held a meeting of the party stakeholders, at the end of which they came up with a line of activities that included unleashing of violence to not only eliminate the APC in Kano, but also to make it ungovernable in the event of Supreme Court judgment in favor of APC. We have it from reliable sources that they are planning a mass protest on Saturday, during which key figures of the APC will be targeted, if possible, to eliminate them. The NNPP resorted to threatening to kill the judges of the tribunal should the verdict of the court eventually be announced and not in their favor.
Joining us now to shed some light on the Kano Tribunal decision from our Abuja studios is the National Legal Advisor for NNPP. Thank you very much for joining us today. We've been having a lot of back and forth, and more importantly, a lot of people have been speaking up. Of course, the appeal court has said that it is clerical error in terms of the Kano Guba judgment. What do you make of this?
Thank you very much, Aaron. Thank you, Tokwe. Thank you, Nigerians. I will address first and foremost the issue of the false alarm raised by APC that NNPP is planning to unleash terror and make Kano State ungovernable. Nothing can be further from the truth. NNPP owns Kano. NNPP is Kano. So why would they want to inflict a self-injury on themselves? That should not be taken seriously. It's the same game, the same antics of creating unnecessary tension and thereby causing trouble. They are crying wolf where there is none. Except they are planning something else, they should tell us. But as for NNPP and Kano, is one and the same thing. So NNPP can never cause trouble in Kano. If we make Kano ungovernable, who is the governor of Kano? NNPP is the governor of Kano. So NNPP cannot cause a self-inflicted injury on itself. Thank you for that. Now, on the issue of clerical error, what I will tell you is that, what is clerical error? The Black Law Dictionary, 11th edition, the Black Laws Dictionary, 11th edition, at page 683, defines what is a clerical error. It's a minor mistake. It is an inadvertence that does not affect the determination or the judicial reasoning of the court. Now tell me, where the court says, I hereby, after making its findings and reaching a conclusion, that I hereby set aside the judgment of the tribunal delivered on the 20th day of September 2023. And went further to say, I hereby allow the appeal of the appellant. And further to that, say I hereby award the cost of 1 million naira against the respondent APC in favor of the appellant, Abba Kabir Yusuf. Is that a minor mistake that will not qualify under the definition of the Black's Law of what's a clerical error? That is fundamental. That's the whole summation of that judgment. It can never be a clerical error. And the Court of Appeal is functus officio at this stage to even say anything concerning that judgment. They are functus officio. They have nothing to do with that judgment. The only body, the only court that cannot look at that judgment is the apex court. So they should just allow the sleeping dog to lie. Enough damage has been done. We are not looking forward to damage control. They shouldn't take us further, creating damage in the media space and creating tension in the public space. That's what I have to say. It is a clear case of a fundamental error in the judgment that the Court of Appeal will look at it. I mean, the Apex Court will look at it. It's not for the Court of Appeal now to be making some statements concerning the judgment that they have no functus official. Going forward from that, at the hearing stage, it was a solemn moment, a very sober moment. On the 6th of November, 2023, at the hearing stage, the hearing commenced unconventionally with an opening prayer, which was solicited by the presiding judge, my Lord Justice M.A. Abumia, JCA. He called for prayers. And good enough, we had at the bar, the inner and the outer bar, very senior lawyers, former chairman body of benchers and the present vice chairman body of benchers, in person of Wale Olanikpekun SN and Chief Adegboyega Awomolu SN. Not excluding Ewujimi SN among OEB Ophium, among others. He called for prayers, and prayers were offered to safeguard, to secure, to salvage the judiciary. That was the theme of the prayer. And the same hearing session ends with another prayer, where my Lord Justice Abumia again called for members of the outer and the inner bar, where he said in a very sober and solemn disposition that the judiciary has never been in its worst trying period as they are facing now. That please, the senior members of the inner and the outer bar should kindly approach their clients and stop them from assessing them, from interfering, from intimidating, from threatening them. That they should be allowed to give justice. That was the foundation under which all this happened. It was in the open court.
Now, Mr. Horn, it's very
this thing
clear.
Happened in the open. It has never, throughout my years of practice, over 20 years, I've never seen it happen this way.
Now, it's very clear that
the
of course, you do not agree.
And ends with a prayer.
Well, it's very clear that you do not agree with the ruling of the appeal court. And of course, you are worried, about the fact that they opened and closed with prayer. But then I'm wondering, and a lot of Nigerians are wondering, if judicial precedents are no longer respected in Nigeria, and what role the Chief Justice of Nigeria and the National Judicial Council can play in ensuring that judicial precedents are respected.
Thank you very much. We are inundated with such conflicting judgments across the Federation, particularly from the Court of Appeal. And I believe, and I'm very confident, that the Supreme Court will rise up to the occasion to review all the judgments and give us our, what we call a ratio descendi, which is that the precedent must be obeyed, or else there will be anarchy, there will be chaos, even in the judiciary. So we are very confident at the bar, even though it has called for serious concern. We are confident that the Supreme Court will rise up to the occasion to right the wrongs and put the judiciary back to its rightful position as a bastion of the hope of the common man, as the aphorism has been dominated in the public space. Going forward from there, if you look at the judgment that was delivered on the 17th of November 2023, the major concern or the major substratum of that judgment is that the candidate fielded by NNPP was not a member of their party. And the justices in their wisdom relied on section 177, paragraph C thereof, of the Constitution and Section 134 of the Electoral Act to say that he's not a member of NNPP. But if you look at Section 177, paragraph Section 177 particularly, paragraph A, B, and C thereof, it has spelled out clearly the requirement to be contesting for governor of a state under our laws. The Constitution states clearly. And the paragraph that concerns the governor, which is paragraph C, says you must be a member of a political party and sponsored by that political party. That is the crust of the matter. Now, the issue is who determines who is a member of a particular political party? Who determines who is a member of the association? In this case, a political party. It's only the party that can determine who is their member. And they can do so. The Constitution did not give them the latitude of how they will do it. The Constitution did not limit them to say you must submit the register of your members to INEC. No. And that is why that Section 77, 2 and 3 of the Electoral Act 2 did not include any penalty, any sanction where a party fails to submit a register of members, only require them to do so. Now, if where the law has specifically stated, be a member of a political party and sponsored by that party, how do you now know who is a member? I will go back to the pleadings of the petitioner, in this case, APC, who are the respondent at the Court of Appeal. In their pleadings, and they attach from EC9, which is particulars of affidavits of Abakabi Yusuf. That is the requirement of Section 29, subsection 1 of the Electoral Act. It's an affidavit where you must state that you are sponsored by this political party, you are a member of that political party, and you won the election. All the requirements must be fulfilled. The constitutional requirement must be fulfilled in that affidavit from EC9. Abba Kabir Yusuf filled that form. It was uploaded electronically by his own political party. He has no right to upload it himself. It's not the political party that has that code given by INEC. The party uploaded his name with all those particulars on affidavit. He swore to an affidavit at the High Court in Kano State. Mr.
Horn, permit me to come in at this point and take you back to the issue of clerical error, because the Chief Registrar of the Court of Appeal, talking about Umar Bangari, has actually spoken, and I will quote him as he has said that purported discrepancies was a clerical error that did not affect the court's decision. Quoting Order 23, Rule 4 of the Court of Appeal's handbook, it states, and I quote, it empowers the court to correct any clerical error once detected by the court or any of the parties in the matter. You are saying that it is the apex court that should determine the outcome of this whole imbroglio.
That's it.
But he is actually quoting the Court of Appeal's handbook, Order 23, Rule 4, which states that which empowers the court to correct any clerical error once detected.
The powers of the Court of Appeal to correct those clerical errors is limited. It's only to the essence of Section 285. 285, I think 7, subsection 7, only to that extent. The Court of Appeal has 60 days by the virtue of the provision of Section 285, I think subsection 7 thereof. They have only 60 days, after which they become functus officio. Functus officio means they have no any other function to perform with respect to that judgment again. And that 60 days expires on the 18th of November, which was Saturday. From Saturday upward, the Court of Appeal has no business. So the Court of Appeal rule act is subservient to the Constitution. And the moment it overrides, it conflicts the Constitution, it overrides the Court of Appeal to further make anything on that document, that judgment. I will read section 285, subsection 7, which is superior to the Court of Appeal Act 23. That's section 23 of the Court of Appeal Act. It says an appeal from a decision of an election tribunal or Court of Appeal in an election matter shall be heard and disposed of within 60 days from the date of the delivery of the judgment of the tribunal or the Court of Appeal. This judgment was delivered on the 20th of September 2023. As at 18th of November, it was the 60th day. Going forward, section 23 of the Court of Appeal Act has no application. It cannot supersede the constitution of the land. That is the law. So what the registrar is telling Nigerians is a figment of his own imagination. He has no powers or traversing. He can never have to do with the judgment again. I think I have answered that clearly. It is between the constitution and his own act, the Court of Appeal Act, which one supersedes.
Now, while making your opinion clear that Kano State belongs to the NNPP, despite the court rulings overturning your victory in the last election, I'm wondering what the NNPP is doing to calm its supporters so that there are no violent protests, just in case you do not get your way at the Supreme Court. You have suggested that the judiciary is under threat. So what happens if the ruling does not go your way? Will you calm your supporters?
Of course, we shall continue to calm our supporters. Being the governor of Kano State is secondary to being an indigenous citizen of Kano State. Remember that in 2019, Abba Kabir Yusuf lost the same thing at the Supreme Court, and there were no crisis. He lost at the Supreme Court, and there was no crisis. And there will be no crisis if he does lose. But I believe that he will never lose. But most importantly, Kano, Abba Kabir Yusuf, with the teaming supporters of NNPP in Kano, are indigenous of Kano. And Kano is more important to them than the ambition of one of them, including the ambition of Kabir Yusuf. Kano is far more important to them than the ambition. So Kano is going to be peaceful. Kano is going to be intact. I was telling you about the overwhelming evidence of the membership of Abba Kabir Yusuf. I even have a document here. This document was also tendered to the tribunal, and it forms the record of the Court of Appeal, where the name of Abba Kabir Yusuf is number 56,209. The document was tendered and was admitted, and the witnesses were cross-examined on it. And the name of Abba Kabir Yusuf is there, 56,209. This is a document, a certified true copy of register of members. To err on the side of caution, NNPP tendered this document in court. It forms a part of the records of the appeal that was decided on the 17th of November. The court has to look at it, all documents before it. The good thing is that the Court of Appeal has a concurrent jurisdiction to evaluate all evidence, documentary evidence before it. So they had the opportunity to look at all documents. Let me conclude. 4 documents were tendered to establish the membership or otherwise of Abba Kabir Yusuf. 4 documents. The Court of Appeal is that we don't choose one out of the 4 documents. And one of the documents is an affidavit from EC9. It's an affidavit of Abba Kabir Yusuf, which everybody is given opportunity upon publication by INEC to contest. That was not done. In compliance with section 229, section 29, 1, 2, 3, 4 thereof of the Electoral Act. So what we are saying here is that section 177 that was relied upon was not in conflict to section 285. The Constitution is a whole document. You don't read it piecemeal. It's a whole document. Same with the Electoral Act. If you are reading section 134 of the Electoral Act on the issue of qualification, you must also read section 29 of the same Electoral Act to see how you can get to the full correct position of the legislature.
But we say thank you very much. We'll certainly be following up on this particular story. Thank you very much for your time here on Newsday.